After the House passes a bill to speed federal permitting, what are the details? How much difference could this legislation make to big development projects? And does this idea have a shot to make it to 60 votes in the Senate and over the filibuster?
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome, I'm Kyle Peterson with the Wall Street Journal. We're joined today by my colleagues on the editorial pages, editorial board member Colin Levy and columnist Kim Strassel. Last Thursday, the House passed a bill to help make projects that require federal permits a little bit more shovel-ready. This is the SPEED Act that went through the House by a vote of 221 to 196, with 11 Democrats crossing the aisle to vote yes. For the record, that acronym stands for Standardizing Permitting and Expediting Economic Development, or the SPEED Act. Always want to recognize those interns that are getting put to work creating those clever acronyms. Colin, I know you've looked at this legislation. What are the details of it, and how much difference could it make to big projects that are going through the federal permitting process?
Sure, Kyle. I think, first of all, just to review a little bit, what NEPA does is that it basically required government agencies to do an environmental review on projects before they're built. So the effect really was to tie these projects up with an enormous amount of paperwork and red tape. It raised costs, stretches on forever. Some projects never end up getting built. I think the average span of delay because of these federal permitting rules was around 4.5 years, but there are some that have been delayed much, much longer. About a quarter of projects take more than 6 years. So when you have projects that are going on in multiple states, it just becomes an enormously complex and mucked up situation by these permitting rules and the associated litigation. So what the SPEED Act would do is basically require agencies to only consider direct environmental effects, not the sort of second order downstream effects that are often pretty abstract and theoretical, but that can have enormous influence on discouraging development. And the bill would also put a governor on lawsuits because it would require plaintiffs, often these environmental plaintiffs, nonprofit groups, environmental groups, to file them within 150 days from when an agency takes action on a project. And they'd have to show that they would suffer direct harm from the project. So that's a big difference. And I think it would put some really more reasonable guardrails on this process.
NEPA refers to the 1970 National Environmental Policy Act. And Kim, my understanding is that that law was passed essentially to create a sort of decision-making process that a project that needs federal permits would get some kind of environmental review to make sure they're not paving over some national monument or whatnot. And the problem, to my mind, is that that decision-making process no longer works because it has gotten totally out of control. And under the first Trump administration, there was a study done by the Council on Environmental Quality, and it said that from 2013 to 2017, the average environmental impact statement required 4 years to get done and ran 669 pages. And then there were some real awardees here. This is the longest one. The longest file was a 12-mile expansion of Interstate 70 in Denver, and it was 8,951 pages plus appendices. The appendices were another more than 7,000 pages. And the point is nobody's reading that, not even the people that are writing all of that stuff. They're working on the Appendix A are reading Appendix B. It has become sort of a way to defend any sort of project against lawsuits, is to just be exhaustive as possible, to cover everything. We have a 15,000 page study. And when we get into court, when some green group from 6 states away sues and says, we don't like your interstate expansion, Denver, they drag the 15,000 page study in front of the judge and they say, look, we covered all of the bases. So from your view, what exactly are the most important parts of this SPEED Act?
Well, can I just point out that the biggest part of it is simply that we have passed this. I mean, because this is remarkable, and I don't think that the House members who voted for this are getting enough credit. As you noted, this was passed in 1970. This law is older than I am, and I'm really old. And it was created for a country that doesn't look anything like it does now. And in addition to that, not only is it outdated and outmoded, but it's become warped. And the very meaning of it has been abused, and it's clearly not fulfilling the idea that the original creators had for it, which was, it was simply meant to, and it was good intentions, it was meant to disclose environmental ramifications of larger products to make sure that we were getting the balance right between our economic development and doing economic projects in a way that didn't just run ramshackle over environmental protections. So one of the things that this does, which I don't think is really come out enough, and it's so important though, is the text of this bill actually clarifies that NEPA is nothing more than a procedural act. It simply requires a process and not an outcome, and specifically not an environmental outcome. And this has been a problem over the years. It's been cast by environmental group litigators and Democratic administrations, and then accepted as such by judges, that the law somehow requires that we do anything and everything we can to protect the environment, including if that means not doing a project at all. And that's not what it was ever meant to be. It's meant to analyze the impacts of a project, and then with that information in hand, allow policymakers to decide how to proceed. A couple of other really important things that this does. It clarifies when something is a major federal action, which is important because we had come to a situation as well where the United States government might just be a very tiny junior partner in a bigger state or tribal project, but because of its footprint was requiring these massive NEPA reviews, even though the federal government's involvement was very small. So this clarifies a project has to be one in which feds have, quote, complete and total control over the project, not just some. Another thing it does is it says that if a project has already been reviewed under another federal law with a similar set of review requirements, or under state or tribal laws that have similar sets of reviews, it doesn't also have to undergo NEPA. It lets agencies rely on science that has already been done rather than having to start from scratch, and to rely on previously completed documents for projects, again, instead of starting from scratch. And then I think one more thing, and Colin mentioned this, but just to put a little bit of a finer point on it, and this was cleaned up a bit by a Supreme Court decision earlier this year, but this really puts it into statute, is it says that NEPA reviews only have to be about the exact project at hand, not their downstream effects, not things that are happening to watersheds 90 miles away, not the possibility that one day this could affect climate. It has to do with the project right there and then. And all of this combined is going to make an enormous difference. That's before the litigation piece. But just the procedural questions are going to make an enormous difference in the speed in which we can get and the ability to get projects done.
There has been some progress since that study that I mentioned about the length of these environmental impact statements. One of them is that ruling Kim mentions by the Supreme Court. 7-county infrastructure was the name of that case. The first Trump administration also undertook some regulatory reform, putting some presumptive limits on these environmental studies and so forth. But Colin, on the theme of Congress, do your job, which is a refrain around here a lot, I mean, there's just much more and in much granular detail that can be done by legislation. And by the way, when Congress goes ahead and passes a bill to change how NEPA is supposed to be put into effect, that is also permanent. That's the kind of thing that the next administration, which may or may not be President Vance or may not be President AOC, cannot just go back and undo. If you can imagine the next president being a big environmentalist and saying, actually, we kind of like slowing down all these projects with 10,000 page studies.
That's for sure. And by the way, Kyle, I mean, in addition to the inconvenience and the project cost overruns that are borne by the private sector and real estate developers and so on, I mean, this is also something that's creating unnecessary costs for taxpayers. You know, government agencies that are involved in this permitting process have to prepare environmental impact statements of thousands of pages long. So there's all these, those sorts of costs involved with that as well. I think the current permitting system is a problem for traditional energy, obviously, and for renewable energy. And just getting some of the bureaucracy out of this process is better for everyone. I think that's why you saw a bipartisan vote in the House. And, it's better for the companies. It's better for the communities. It's better for the country's ability to move forward and get more energy on the grid, which is something we're certainly going to need. There's no question that NEPA has been just such an enormous weapon of environmental groups that want to delay or derail projects they don't like, and they can tie things up with these thousands of pages of documentation. So I think just getting that off the books and no longer allowing it to be used to slow everything down and slow all development down is going to be better for everyone.
Kim, what about the prospects in the Senate? This bill has now gotten through the House, but that is the easy part sometimes, because in the Senate you have the 60-vote filibuster rule for legislation. That means that Republicans, they control the chamber. They will still need a few Democratic votes at least if they want to get any kind of substantive permitting reform through.
Before I jump into the Congress, I just want to mention two more quick things about what this does. One thing, because Colin mentioned it, it really increases certainty for developers, because it wasn't just the fear of coming to do a NEPA review, but then the fear that even when it was going to be done, that an administration would come back and pull the plug and say, just kidding, we're not going to let you do this. So the bill actually makes it harder for federal agencies to revisit or revise previous authorizations. That's important. And then the new judicial restraints that Colin mentioned. There are new limits on how long outsiders have to file their claims, but also, this is really important, it actually limits the ability of judges to throw spanners into this. Under this, they'll still have the ability to remand a NEPA review back to the agency and say, we don't think this is good enough. But they'll be more limited in issuing injunctions or vacating permits, which is something that they have the ability to do now. So that's all really great. When it comes to Congress, as somebody who does complain a lot that Congress doesn't do its job, the House does get huge credit for this, because, again, they are revising a 55-year-old law that really, really needed it. And this is exactly what Congress should be doing. There is support for this in the Senate, bipartisan support. One problem is the way it was passed in the House. At the very last minute, some wind opponents who demanded that in order for them to get their votes, these were Republicans, to put in there a different standard of review for wind projects, or essentially to maintain the Trump administration's right to reject wind authorizations and wind projects. This soured a lot of Democrats in the House on this. And while there were 12 Democrats who voted for it in the House, there might have been a bigger number had that provision not been added at the last minute. It may well be a little bit of a problem in the Senate. You are correct that there are Democratic senators who have come to understand that their own cherished projects, especially in renewable energy, but also development in their state from a bigger perspective, bridges, roads, tunnels, which are crumbling across this country and really need to be fixed. They're having trouble getting those done too. So they recognize the need. I would expect that there's going to be some further debate and negotiation over this particular wind provision. And the real test of the Senate is, can they come to an accommodation, and is that then something that can pass through the House again? I sure hope so, and I hope that a lot of attention is put on this, and that this is made a priority, because if you really care about the economy and you care about getting this country sort of moving, and if the Trump administration cares about its energy agenda, which is put, it's put central to what it's been doing, this is going to have to be a kind of baseline thing that they get done, and so watch the space in the Senate.
Colin, what was your read of that jockeying in the House over this wind provision? I mean, that is the difficulty always, is, again, NEPA is supposed to be a process law. It is not supposed to have a weight on the scale for any one kind of project, but there's always a handful of Democrats, more than a handful, who say we like permitting reform, except not for fossil fuel pipelines, not for natural gas. And apparently you have a faction on the right who says, we really want the ability to cancel those wind farms too.
Right. I mean, I think one thing about the idea here is that it really is supposed to reduce permitting delays across the board and create more predictability for all projects. That means real estate development. It means clean energy projects. I just think that the best way for this to get through is for all these different businesses and all these different development projects to just have more of that and not be getting all snared up, in all these different kinds of delays. I think the real test in the Senate is whether they'll be able to get this through with their own green groups, among the Democrats. The SPEED Act would really be cutting into the lawsuits that these groups bring by this, the provisions that Kim was talking about, reducing the statute of limitations to 150 days. That's going to make a big difference. And I think that the concerns, that having a shorter statute of limitations and limiting the environmental review process to address direct environmental effects, was somehow that's going to really weaken the ability of affected communities to have a say in projects. I mean, that's the concern that Democrats are bringing. They're saying, look, this is going to sort of affect local communities who won't be able to push back. But I think that's overblown because, especially a lot of times it's not the communities that are objecting. It's these outside environmental groups that are bringing the majority of the NEPA challenges.
And by the way, I'm sure nothing makes for a better press release and fundraising pitch for them than we are suing this big oil company over X. Please help support our litigation. Kim, the Journal's editorial on this bill earlier this week made this statement: with the tax bill done, Congress has no higher priority than permitting and NEPA reform. And I wonder if President Trump is going to get behind this potentially in a big way in the coming year, if that is the case. And we've talked a lot about the state of the economy, whether it is looking a little bit shaky these days. President Trump wants lower interest rates, but the inflation numbers don't seem to support that. His tariffs are a problem for a lot of companies, including small businesses, manufacturers that are relying on steel or parts that are imported. And so if there's some juice to be squeezed from permitting reform, and by the way, it's an idea that is a good one that conservatives and Republicans have been pushing for a long time, is there an opportunity here to make the case to the president that if he can get this bill through, I mean, I grant there would be some lag before any sort of new projects get up and running, but maybe you can get some increased confidence, some increased investment in a way that might be good for the economy.
Oh, it would be huge. And let me assure everyone, the Trump administration does know that. We have actually had some real progress on this in the last few years, I would say. And it did, I would note, it did begin with a bill that Biden signed, although only because Joe Manchin essentially forced him into doing it in return for a vote for a Biden priority. But that began to loosen up the process a little bit. We had this Supreme Court case, which was a very good precedent. But the Trump administration roared into office, and the heads of his different agencies that are involved with this, in particular, Chris Wright at the Energy Department, Doug Burgum at the Interior Department, and Lee Zeldin at EPA, have made a priority of this. So the president has done as much as he possibly can through executive action, but there are limits, as you note, to that. And the three of them, his cabinet secretaries, have done a great deal to try to coordinate and streamline the process that they do have to the greatest extent possible. They understand that, in particular, this energy agenda is contingent upon legislation like this passing. It will be really interesting to back up what Colin said. It may require the president to realize that it's worth giving a little bit on this wind issue. He has really socked it to wind. He has some real issues with the wind industry. I do think that there is some question over whether or not some of these wind projects were green-lighted without going through the reviews that everybody else has had to go through, and that's been the concern. And indeed, this provision in the House was brought up by in particular, Jeff Van Drew of New Jersey, a Republican who has been very, very frustrated, and Chris Smith in New Jersey with the wind projects there, because New Jerseyites have really been slammed by a policy that was pushed by the governor there that has backfired to a large degree and really made electricity prices soar. But the president might need to understand that this is something worth to doing a little walk back on, if it means he gets this giant bill that allows the rest of his priorities to go forward. That might require sort of some real pushing in the Senate to roll back that provision some, and then some hammering on a couple of those House members, to get them to accept whatever revisions are made in the Senate when it comes back to the House. He obviously has the heft to do that if he decides to kind of get, have a couple personal conversations with some of these folks. But that would certainly be in the administration's best benefit. And I'm pretty sure that's probably the advice he's getting from most of his cabinet officials and advisors.
Well, permitting reform would be a pretty good legacy for a president. Colin, I mean, I raised the economic question a moment ago, whether it would help the economy going into these 2026 midterms. But Kim brings up an even better point, maybe, which is that there are a lot of voters concerned about rising energy, electricity prices. I mean, I think Republicans are on the right end of that argument, that especially in blue states like New York, New Jersey, where you've had governors and state legislatures that don't want any sort of pipeline infrastructure coming in, that has created some of those rising costs for voters and consumers. And here's another place where, if the Trump administration can get this done, it won't be immediate relief for people, but Republicans could go to the ballot box in November of 2026 and say, look, we had a problem here, and Republicans under the Trump administration are working to solve it. Here's the bill. We're signing it into law.
I think that's so true, Kyle. I think people are enormously sensitive to those price increases. That's true across the country. And I do think that these reforms are going to really be felt pretty acutely in some states as well, particularly in the western states where you have enormous amounts of acreage that are designated as federal land. And just doing anything in that area triggers these federal permitting requirements and grinds things to a halt. I mean, I think people are going to be grateful for the changes on both ends, both for the way they can, increase the amount of energy, potentially reduce costs, and also just get communities working more easily, developing more easily, without such enormous bureaucratic hassles. I think it's been enormously difficult for people that are living there and constantly having to consider, not just the immediate environmental impact in their own communities, but as we've said, any downstream effects of their actions, and the litigation that comes from the environmental groups that just want to stop things at all costs. So yes, I think politically it's certainly a winner.
Thank you, Colin and Kim. Thank you all for listening. You can email us at pwpodcast@wsj.com. If you like the show, please hit that subscribe button, and we'll be back with another edition of Potomac Watch.